Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to Our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is Christina Ma, and today's topic is, what does it all mean? Wu, Kahn, Kanter, and antitrust reform. Tim Wu, Special Assistant to President Biden for Technology and Competition Policy, Lina Khan, Chair of the Federal Trade Commission, and Jonathan Kanter, Presidential Nominee for Assistant Attorney General of the DOJ's Antitrust Division, the tripartite of Biden antitrust leadership, embody a near decade-long debate on the role of antitrust policy, particularly during the rise of big tech and data. In this episode, we speak with a former chair of the Federal Trade Commission to understand the significance of these appointments, leadership, and what it may mean for antitrust policy and reform going forward. Joining me today is my co-host, Melissa Maxman. Hi, Melissa.
Hi, Christina.
So no question, it's an interesting time to be part of the antitrust bar. Can you tell me a little bit more about what we'll be discussing in today's episode?
Sure. Well, antitrust has been in the popular press in an unprecedented way, starting last year, really about during the pandemic. We've seen the filing of big tech cases against Apple and Facebook and Google, and we understand that there are investigations going on in the U.S. government against Amazon and others. And the interest in high tech has even taken precedence over the attention that's been paid to big pharma, although that's also been in the news in the antitrust sphere over the last 5 years. In fact, very recently there was a Wall Street Journal article called The Return of the Trustbusters, which outlined the new approach to antitrust that Lina Khan in particular and Tim Wu and Jonathan Kanter are expected to take on behalf of the Biden administration. And that's what we're going to be talking about today. How much are things really changing and what does it all mean?
Great. And who do we have to discuss this interesting topic?
Well, I am honored and privileged to be able to introduce Bill Kovacic. Chairman Prakash, he was the former FTC commissioner from January of 2006 until October of 2011, when he was, and then he was FTC chairman starting in March of 2008 to March of 2009. He was an antitrust professor at George Mason University, and he now teaches at GW. He's the director of the Competition Law Center at George Washington University. He has quite the resume. Since 1992, Bill has served as an advisor on antitrust and consumer protection issues to the governments of Armenia, Benin, Egypt, El Salvador, Georgia, Guyana, Indonesia, Kazakhstan, Mongolia, Morocco, Nepal, Panama, Russia, Ukraine, Vietnam, and Zimbabwe. That's a very long list in alphabetical order. And he also currently serves on the International Committee of the Institute of Competition Law. He was appointed as a non-executive director to the UK Competition and Markets Authority on July 15, 2013. And he's also a visiting professor at the Dixon Poon School of Law at King's College, London. Welcome, Chairman Kovacic.
Thank you, Melissa and Christina. It's a real treat to be here. I'm thrilled and honored to be part of the conversation today. Thank you.
Well, we are honored and thrilled to have you, somebody as experienced and has a historic vision of what's going on, to be able to help explain to our audience what to expect going forward. Let's start with Wu, Kahn, and Kanter. Who are they? Why do they matter? What do they represent in their present roles compared to the way the FTC was when you were chair?
They represent a dramatically new way of thinking about what we should do in the competition policy sphere. I think if we were to go back 5 years and to take a bet, would you predict that the three would achieve the preeminence and the appointments that they have so far? I think most bookies would not take the bet. They would say, of course, it's our job to take your money, and we like doing that. But to be a fair wager, there has to be some faint plausibility that the event could occur. and this is so far-fetched that we think you should keep your money and go out and buy yourself a nice cup of coffee. They wouldn't have done it. This is a true transformation in the enforcement framework. Tim Wu and Lena Khan are colleagues on the faculty at Columbia Law School. They are part of a significant movement that seeks not just to amend antitrust policy, but to transform it at its core, to bring it back to its egalitarian roots, which featured prominently in Supreme Court decisions as late as the 1960s and early 1970s. Jonathan Kanter is an experienced practitioner. He doesn't quite have the pure thoroughbred public interest background of Lena Khan and Tim Wu, yet he has been active on behalf of antitrust complainants in antitrust cases. He is regarded by the proponents of transformation to be a strong candidate to lead the fight for a basic change in the Department of Justice. So we have a coalition that has truly accomplished a takeover, a major takeover of the antitrust leadership with the potential to bring about a sweeping change in enforcement policy. Nobody saw that coming, even 5 years ago. I even doubt if, imagine Chair Khan as a law student 5 years ago being asked by a recruiter, what do you plan to do in 5 years? And she said, I plan to be the chair of the Federal Trade Commission. I think the recruiter would have said, we're finished, and good luck in your delusional career. That's never going to happen. Yet it did. And what they have accomplished in achieving these positions of leadership, or in Jonathan Kanter's case, near leadership, is truly extraordinary in its own right, and a testament to their guile, their intelligence, their fortitude. I don't think we've ever quite seen this before in our lifetimes.
And we're going to come back in a minute to their intelligence and fortitude, and I would say vision for the future. But I want to turn for a minute to another series of changes that are going on, the legislative rumblings on a bipartisan basis in Congress. The House Antitrust Subcommittee is focused on tech antitrust. The Senate's Antitrust Subcommittee has focused so far mainly on pharma. But on June 24, 2021, the House Judiciary Committee passed a series of 6 sweeping tech-focused reforms, and they addressed a variety of things, including changing merger rules in a dramatic way to, first of all, increased fees, also to basically prevent dominant online platforms from using their market power to pick winners and losers, and eliminate what has been referred to in the trade press as killer acquisitions. There have been a number of other somewhat controversial bills floated, and with in the context of the pharma bills in the Senate in July 2021, they have been focused on trying to reduce prices for consumers. How likely do you think any of these legislative reforms are, and how does this fit into the executive branch agenda?
I mean, if we look at the agenda, I think it's helpful to acknowledge how extraordinary this set of proposals is, without regard to whether they are adopted. You have to go back to the 1970s, the decade of the enactment of Hart-Scott-Rodino, the enactment of the 1974 reforms that, for example, changed the antitrust criminal offense from a misdemeanor to a felony. You have to go back to the 70s to have a comparable period of legislative ferment. I suppose the one element of the entire package that is most likely to be adopted is the proposal for a dramatic boost in resources for the Federal Trade Commission and Department of Justice. I think there seems to be a broad bipartisan awareness that there's a huge gap between the commitments that we want the agencies to make and their capability to deliver. We're basically asking for them to go to the moon, and we can't really send them to Kansas City. It's a terrible mismatch between capabilities and commitments. So we'll get that. And maybe we get that even by the end of this calendar year, or not much into the next year. It gets harder after that. And a key question is, how many measures is this interesting coalition of, let's say, the decided left within the Democratic Party and the decided right within the Republican Party, how much is this coalition going to prefer, one, a basic makeover of controls for tech and tech alone, or B, a broader transformation of the entire framework applicable to all commerce? That is a somewhat unstable and unpredictable coalition, but I find it hard to cast aside the conclusion that we will see some measure that indeed is focused on tech. My assessment would be they'll begin with merger control, and we might see legislation that seeks to limit severely the ability of dominant firms, tech firms, to buy a whole range of competitors, including small firms. So I think the next thing on the runway after resources will be merger control. Following that, in order of difficulty, dominant firm behavior and enhancement of the Section 2 Sherman Act framework. And last, and maybe most difficult, is the adoption of a new regulatory framework for online platforms, including the granting of broad, specific rulemaking authority to the Federal Trade Commission to adopt specific prescriptions dealing with big tech. So resources, first, foremost, a lot more. Second, after that, merger control. Third, dominant firm behavior. Fourth, most difficult, platform issues. I suspect what's happening among the tech firms now is that they're asking, what line of defense should we build? Should we be willing to give something up in the hope that one big symbolic punch in the face for tech will be enough to placate the Republicans, and they won't go farther than that? How long does this take? I wouldn't see these tougher measures coming into place until mid-late 2020. As we know, we have by-elections coming up in November 2022. The margins in the Congress right now are razor thin for the Democrats. So they'll probably need this larger coalition of conservatives who see tech as a menace and Democrats who see tech as excessively powerful in its role in controlling the economy and perhaps the political process as well. But it will be a long, long way to Tipperary to get that larger package of measures in place.
Well, let me ask you this. Oh, go ahead.
Bill, you had mentioned, Tim Wu, Lena Khan, Jonathan Kanter having accomplished a lot to date. Obviously, Jonathan Kanter's not yet appointed, but what can they accomplish? What have they accomplished to date in the absence of some of these legislative reforms, and what can they do within the confines of the existing laws and rules and regulations?
To date, they've changed the conversation. That is, we are talking about issues as mainstream concerns that have not received this kind of prominence going back to the 1970s, where the broader egalitarian vision of antitrust law disappears in Supreme Court decisions, roughly from Brunswick in 1977, Sylvania in 1977 onward. They brought that back into clear relief. So the whole conversation about the field has changed. They didn't do it alone, but they had a crucial role in doing that. They're also using soft power mechanisms, that is, withdrawing the FTC Section 5 policy statement, issuing commands that say, we will look at mergers much more closely. We're going to abandon the principle that we wouldn't insist on prior notification in settlements. It looks like the commission is soon poised itself to abandon its participation in the 2020 vertical merger guidelines, along with other broader statements that say, we're going to be tougher on mergers. What we haven't seen yet are the cases that back that up. The soft power tools only carry you so far. I think they do catch the attention of the business community. On Tim Wu's part, he was a driving force behind President Biden's executive order on competition policy issued in early July. That is largely aspirational. That is, it sets out a broad vision of competition policy. It's the most sweeping presidential endorsement of competition as a tool for economic progress since the second term of Franklin Roosevelt's presidency. statements Roosevelt made in the late 30s, early 40s. No president has issued such a broad command, but its effectiveness depends crucially on follow-up by a variety of regulators such as the FTC, other government departments. The order itself does not specifically inject new policies into the bloodstream. It requires intermediaries to act. And a big question there is, will there be the fortitude, the commitment, the perseverance to carry that out? I would see it as being, in effect, where we are now. We've been on a roller coaster, and on a roller coaster, there's a point where it's climbing to the top. And it often goes very slowly as it creeps toward the top. We're on that phase of the climb, but we're not yet to the top where it begins that thrilling plunge that gives you a sensation of weightlessness. That is, we've not seen new big cases. We have not seen the execution, as the FTC has suggested will happen, its chair, new trade regulation rules. We have not seen the prosecution of new big merger cases. So in many ways, the hard tools that really reshape the boundaries of policy, we're waiting for those yet. And in order to do that, that'll take a bit of time. In the case of Chair Khan, she has a voting coalition of 3 now, but one of them, Rohit Chopra, Commissioner Chopra, is scheduled to go to the Consumer Financial Protection Bureau pending Senate confirmation. When he leaves, it's 2-2 at the commission. And we may go through a 3 or 4 month period in which the chair has a 2-2 deadlock and cannot use these harder tools to carry out her program.
Well, let's talk a little bit about the ongoing litigation that we know about. For example, there is ongoing litigation filed by the Department of Justice against Google, and a number of attorney generals have joined in that. We know that the FTC has a pending case against Facebook, and we also know, I'm just talking about the big high-tech firms. We also know that Amazon has filed an HSR to purchase MGM, and my understanding is a second request was issued on that not long ago in the FTC. Are the agencies able to move forward on those cases without legislative changes? In other words, without new bills in Congress?
I think, Melissa, the answer is yes. I think there's a way to win those cases even without new legislation. What we know from what we've seen so far is that those cases will be hard to do, especially the monopolization cases. There'll be nothing easy. I saw a couple of academic commentators who I think should know better refer to the Facebook case by the FTC and the New York Attorney General's office and other AGs as being a slam dunk. It only suggested to me that they need a refresher in basketball as well as antitrust. These are hard cases. They're very hard cases. And they're going to take a long time. The Google case by the Department of Justice is not scheduled to go to trial until September 2023. That's 2 years from now. And that generates a decision perhaps in the first half of 2024, the inevitable appeal to the D.C. Circuit. We're into 2025. And if the Supreme Court took the case, we get a decision in June 2026. That's 5 years from now, which, by the way, I think gives impetus to the argument that maybe we need new legislation because our system is not fit for purpose. I don't see Facebook going any faster. I mean, we've seen how hard that case is, given what the district court did in dismissing the New York case with prejudice, dismissing the FTC case with leave to refile. They refiled. We're going to get the inevitable subsequent motion to dismiss, and probably the judge won't start scheduling the proceedings, the discovery, until sometime in the early part, the spring of next year, 2022. So that case is on a long, slow path, as are the cases brought by the states against Google. It's all a way of saying that that it's going to take a great deal of time in these sectors that change so fast. Are these really fit for purpose, especially if you need intervention now as opposed to much later? I do think there is a jurisprudential path to succeed. It is a difficult one, and it will require all of the imagination of the agencies to take the footholds created by cases like U.S. versus Microsoft and the per curiam opinion by the D.C. Circuit in 2001, to take cases like Lorraine Journal, McWane at the FTC, a host of cases where plaintiffs have won in the face of daunting jurisprudential barriers, and to design a path to the summit. It's possible to do. It can be done. It's going to be very difficult. And for new leadership, I think it's going to sink in clearly for Chair Cohen. It will sink in on Mr. Kanter, should he be fortunate to be confirmed, is that before I roll out my own new program, I have very significant old business to deal with. And you cannot skimp on it.
And in that regard, I want to point you to a recent decision that just came out on September 10th, 2021, where in the battle between Epic and Amazon, Judge Yvonne Gonzalez-Rogers in the Northern District of California just issued a ruling where she kind of split the baby. She did rule that Apple was not a monopoly, but she did order Apple to make some changes in its App Store regarding how it allows outside access and how it charges its users or allows its the apps that it carries on its App Store to be charged to its users, and it will cost Apple money. I don't know if you've had a chance to review that case, but I wonder if that's a portent of things to come. No doubt it'll be appealed to the entire Ninth Circuit, but we heard a lot about in the summer that ongoing trial. And given that we have that recent opinion, which has yet to be really digested by the antitrust bar, I wonder if you have any comment on how that relates into to the judicial options that we know about now.
Yeah, as you describe it, Melissa, I think you got it just right. The Epic lawsuit against Apple did involve a mixed result before the district judge. Apple walks away with a clear statement by the judge that it is not a monopolist, which must hearten it, and I suspect other big tech platforms, that judges are not immediately going to join the view that they are so big, so powerful that they have monopoly power, that will be a contested issue. At the same time, she did find some of the App Store practices to be an infringement of antitrust law. And that's a significant gesture. I don't know that you have to topple the entire edifice of the company to have an effect. And if that element survives judicial review, if you take her decision, Judge Gonzalez's decision today, you take that and add it to the mass of other litigation in which Apple at home and abroad is facing challenges to the same practices, other private cases, public cases outside the United States, you have a force that I think is going to wear away at some of the restrictions and barriers that exist. And I think it has unmistakably inspired efforts by Apple to offer concessions on its own. Apple has been retreating a bit. So even if we don't get to the big decisive decision that unwinds the monopoly power and takes apart the entire edifice, I think we are seeing collectively a set of measures that can create breathing room for rivals and other developers that can be significant over time. So the mere fact of the cases, the fact of this mixed result but has good things for plaintiffs, all represent, I think, significant developments and can have a powerful effect on the sector, even though we don't have the big decisive battle that goes one way or another.
Let's try to give our listeners a little bit of the historical context about what are the philosophical scaffoldings between what are seen as the Wu, Kahn, and Kanter approach and the more traditional over the last 30 to 40 years approach that your FTC, when you were chairman, represented. And going back again to this trust.
And a golden age it was too, Melissa.
I am sure. And I'll come back to that.
Just to be clear for everybody, thank you.
Yeah, I don't disagree entirely. The Wall Street Journal article in the Return of the Trustbusters, he talked about a lot about the dichotomy that was set up by Lina Khan and her adherence to Justice Brandeis's teachings, and what's seen as the Chicago School Robert Bork approach to antitrust, the antitrust paradox. Can you give our listeners who may not be completely familiar with this a short précis on what are we talking about as a practical matter here?
I think the most important element of the Kahn-Wu-Kanter philosophy, most clearly held by Tim Wu and Lina Khan, is the view that the proper function of competition law is a broadly egalitarian vision that seeks ultimately to protect democracy itself, to ensure against the amalgamation of economic power that not only distorts the functioning of the economy, limits opportunity, makes the economy more sluggish and less permeable for people who want to enter and use their skills, but also has the effect, unless challenged, of warping the political process to the point that private enterprise becomes an alternative government with the capacity to supplant the government itself. And I think if you were to ask the chair of the FTC and her intellectual cohort, what's the point of the law? The point of the law is not to put a few more dollars in our pockets as consumers. The point of the law is to protect the democratic process itself as an end in itself. That is a distinctive return to a point of view that has been powerful in the U.S. at different times, espoused indeed as it was at times by figures such as Louis Brandeis, but fell out of favor in the late 1970s when I would say a coalition of so-called Chicago school figures with Robert Bork as their main exponent, commentators such as Philip Arita at Harvard, who both said that egalitarian vision is not subject to effective implementation. You can't put it into effect. It involves trade-offs, and you don't want to tell a single district judge or a jury or an enforcement agency, do what you can to preserve democracy. How do I do that? That you'd get impressionistic results, person by person, in trying to put that into a place. This coalition that emerges in the late 70s says the only thing you should ask is, does the behavior make consumers better off or worse off, especially in its capacity to deliver a product at a lower price, but also more innovation, better quality, but it's the consumer focus alone that matters. And what is so distinctive about the new movement for transformation is, in a sense, sometimes they're called radicals, but I think they would say we are not radicals. The radicals are the people who displaced this vision that Congress had in mind, that the nation embraced for so long. We are not radicals. We are restoring to its proper place a view of competition law that prevailed in the past, that made our economy function well, that served our democracy well, and that's what we are trying to accomplish. That is first and foremost the starting point for their view, and it collides with the view of the Chicago team. It collides with the view of many others, a group in the middle who want to expand the system, but with a microeconomic policy focus.
Yeah, Bill, you mentioned earlier this being part of a roller coaster ride. I think that history certainly highlights just how much we've changed and gone back and forth, and it'll be interesting to see what this new, I guess, originalist, egalitarian administration will bring. Given your long and storied career, do you have, predictions for the new administration, and I guess more saliently, any advice for them if they are to successfully implement their program?
I think if we look ahead again and we look at accomplishments, the new administration will have durably changed the debate. We're going to be talking about these issues for a long time. We're going to be talking about who should head agencies, We're going to be talking about the possibility that our system became timid because the revolving door imbued it with non-interventionist perspectives. We're going to be talking about whether professional societies, such as the ABA, of which I've happily been a part my whole professional lifetime, facilitated that process by encouraging a timid, cautious approach to enforcement. That debate's going to go on for a long time. And I suspect for our system, that's a healthy thing. We ought to be asking these questions. That lasts. What about the specific success or failure in putting a program in together? I think the biggest challenge for the new team is going to be to pick a handful of priorities and to mass their effort behind them. That is, when you look at the president's executive order, he has dozens of ideas there. When you look at the commands coming from Capitol Hill, they have a new idea a week for the new chair. And part of the problem for the new chair is the expectations she has created by her appointment are not just stratospheric, they go out through the solar system. And we have a whole group of individuals who look at her as being an antitrust Joan of Arc who can fix it all by the power of her vision and her courage, but that's going to be really hard to do. You can't have 50 priorities. I think realistically you can have 3, maybe 5, and you have to pick of all the things you have, what's your top 5? The day you walk out the door, what do you want to have that newspaper column say about you and what you tried to do? And by the way, on your top 5 for the FTC, one of them's Facebook. You've got to do your best to win that case. But what else are you going to do? Same question for Jonathan Kanter. What are your top 5? I think if they focus on the top 5 single-mindedly, they have a chance for accomplishing some specific, durable changes. For example, do you put in the top 5 the wholesale revision of federal guidance that exists now? Revise all the merger guidelines. Revise the collaboration guidelines. Revise the healthcare guidelines, IP guidelines. Go back and retool them all to bring this egalitarian perspective back into full view. Do you spend your time doing that? Do you say, by the time I finish, I'm going to litigate 2 vertical merger cases and I'm going to win them? Do you say, I'm going to start a new abusive dominance case? Do you say, I'm going to issue a trade regulation rule that forbids covenants not to compete in employment contracts, or forbids pay for delay agreements involving generic producers of pharmaceuticals and non-branded producers of pharmaceuticals? What are your spots going to be? And part of the difficulty is, I think whoever looked at it, I spent a lot of the last 10 years since I left the FTC doing interviews with other heads of agencies, with a couple of different publication groups. And I've asked them the question, what do you know now that you wish you'd known on day 1 of your job? And a consistent top handful of recommendations includes this one. If you don't ruthlessly focus on a handful of priorities that you want to do and communicate those to your staff and to the outside world, you will not succeed. If you have 50 top priorities, you'll try them all and none of them will be excellent. So your aim has to do the top 3 or 5 that provide a foundation for building on the future in the hope that you will have successors who want to carry this out. Because, by the way, you can't do it in 3 or 5 years. You will need another generation of leaders who accepts your vision. This is a relay race. You can run a wonderful leg on your own, but at some point, you have to hand the baton off. And the person who takes it has to be willing to take it and run that race instead of throwing it aside and saying, I'm not participating. You'll need more time to do it. You'll need President Biden to pick judges who care about antitrust on the courts of appeals. So I would say the hardest thing is to say, what's your top 5? And single-mindedly pursue those. And if people say, oh, that's not enough, you have to do more, to say there's a lot of history that says if you try to do it all, you'll do none of it.
Very good advice for all these incoming leaders. Bill, before we let you go, we do like to ask all of our guests a few personal questions. The first I'm going to ask is to tell us something about yourself that we wouldn't know about you if we only knew you professionally.
I suppose the thing that interests me most is I've had the chance in working over time to see the wisdom and the efforts that we're all making to ensure that we attract talent into our field wherever it resides. That you want and you succeed over time by the intuition in books like Moneyball. Even if you hate baseball, Moneyball is a book you have to read. Why is it important? It tells you that you look for talent in unconventional places. And if you have the habit of defining good talent simply in terms of what's familiar to you, and specifically people who look like you and are like you, you're missing a good game. And I've seen so many instances globally in which a society, a profession that commits itself to allowing people to realize the fullest expression of their skills and actively looks for them will not only probably be a more prosperous society, it will have a greater sense of social fulfillment, personal fulfillment that makes your society, in a basic way, a better society. And I see that as crucial for our profession. And it means that I applaud the effort that we're making and continue to look for talent wherever it exists and to make sure that we are not limited by habits, customs, and practices, where the only question we ask ourselves is just talent. Just talent. That's what we want to see, and we want everyone to get a chance at it because that's how you prosper. I've had many occasions in the last 30 years to see this in so many countries and to see how countries that open the door for everyone to get a chance. I don't think individuals expect to prevail, to always be the best. I think we come to realize that there are other smart people out there, and at some point, there's probably somebody better than I am. But I want a chance to play. I want a chance to do my best and see how I perform at the top of my game. And if at some point somebody else surpasses me, I can accept that. It doesn't make me happy, but I am fulfilled because I was able to give it the best possible chance I had. And I think all that we do professionally, all that we do in our working life, in our professional societies, to give people that chance, it's how you open the doors. At King's College on the Strand, in their law school campus, they have a gallery of many of their greatest alums. Now, the older part of the gallery has a lot of white guys. But as you come forward, you see the Hall of Fame, people like Rosalind Franklin, indispensable to making the ultimate discovery of the double helix possible. You see a larger and richer collection, and you realize that if things hadn't happened to open some doors, that gallery is impoverished. It's a lot weaker. And when I walk by that, every time I go into the King's campus, it reminds me that it is creating the possibility to realize the fullest range of capabilities we have is the only way we're going to get better.
Great. Thank you, Bill. We also have a question for you from our ABA Young Lawyer Rep, Sarah Jong.
We love hearing about a good war story. To the extent you can pick one, what was your favorite case that you've worked on?
The matter I worked on that I am happiest with was a consumer protection matter. It was not an antitrust matter. It involved the preparation of the do not call rule and its ultimate successful defense before the federal courts. The do not call rule involved some major risks. There were doctrinal risks about whether the First Amendment was compatible with the rule. There were technical risks about whether you could put together a network that could receive lots of registrations and function effectively. And there were political risks because although Congress as a whole supported it, there were very clever and effective opponents that sought to derail it. And there was less the technological risk of whether or not the rule could be adapted over time. And we had blind spots about how important mobile would become and how adaptive firms would become. Firms do not surrender in the battle to do something they find valuable. They adapt. And there's been a rethinking about the rule and about tech rulemaking in light of that. But the moment I liked best in all of it was the day that we lost the second of 2 preliminary injunction motions to enjoin the rule. 2 district courts said you can't apply the rule for different reasons. And I remember when we heard the second one, we had a senior staff meeting. I was the general counsel at the time. We had a senior staff meeting with the chair, Tim Muris. I was feeling pretty low. The point of a general counsel is to win cases, not lose them, especially flagship matters. And the entire senior leadership team was dragging their chins on the ground. It was a bad moment. At that moment, the chair of the FTC said, let's get to work on fixing this. Let's get Congress to patch a gap in the appropriations process, a lapse that the court identified. In 2 days, the president signed new legislation approving a fix, a breathtakingly fast legislative solution to part of the problem. But he said, we're going to go ahead. We're going to go get an emergency stay. And I remember that one of my colleagues, who was one of our best appellate advocates, said, it's not working. I argued both of the cases at the district court. I could do the appeal. If you want to pick somebody else, I understand. And the chair said, absolutely not. You're doing exactly what I asked. You're pursuing the strategy that I chose. That's my strategy. If it fails, that's my fault. And I take responsibility. All of you are doing a great job. I think you learn the most about people when times are bad. When times are good, the love just falls out of the sky because you're having success. It is the face of failure that causes panic and terror. But at this moment, the chair said, I will be responsible if it doesn't work. You're doing a good job. We're going to get a stay. We did. The Court of Appeals was a favorable panel. We prevailed on the merits. The Supreme Court denied cert, and the rule went ahead without a glitch. What I thought was going to be my worst day at the FTC became in lots of ways my best day. And that's what I remember most. It's the best exhibition of good leadership I've seen in my life, where the good leader personally says, I'm responsible for the outcome. And when things worked well, he stepped into the background and said, the success is all yours. That's my best day in the field of antitrust and consumer protection.
It's a great story, Bill.
I feel like cheering.
Yeah. Bill, you've given us a lot to think about. I'm sure our listenership will appreciate your time today. So thank you for joining us. And for our listenership, thanks for listening in.
Thank you for listening to this week's episode of our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.